We thank you so much for watching Law School Made Easy at Law School Made Easy 256. We ask you to subscribe to our channels. All the leading cases, locus cascas cases, are going to be discussed starting with this week, and we shall put them on Voices of the Bar. So we have a channel called Voices of the Bar. Ensure that you are subscribed to that channel, where we shall put all cases for criminal, evidence, tort, contract, family law. And for family law, all your videos of family law, 75% have been uploaded of first semester family law year 1. So the family law first semester, all the videos are on Voices of the Bar. So ensure that you are subscribed on that channel that is called Voices of the Bar. So today we want to discuss tort law, the law of tort, and we want to discuss trespass to persons. Under trespass to person, we have assault, battery, false imprisonment, and malicious prosecution. But we are going to start with assault, and this video is strictly discussing assault. We are going to go straight into the elements of assault, the meaning of assault, and then our next video in tort law we shall do battery, and then we go for false imprisonment, and then we go for malicious prosecution. Yes, we could do one video with all of them in there, but because tort tends to be tricky and stubborn, disturbs a lot, we have decided to do one video at a go. So when we discuss assault, colleagues in second year have come across assault under criminal law. And this assault is both civil and criminal law. You can charge somebody in civil and also charge them in criminal law. Now, in criminal law, assault is taken to be both battery and assault. That in criminal law, when you beat someone, that is assault. Okay? When you do things which put that person in fear, it also becomes assault. But in tort, what we are discussing, this is totally different from the criminal law side. When we talk about assault under tort law, we mean that someone has been put in fear, threat. Somebody apprehends fear and is in fear of immediate battery. Now, the distinction is that in tort, assault in tort, contact is useless. Contact is not necessary. You don't need contact in assault in tort. But the thing is, you use threat, you apply threat, and someone is in fear of imminent danger about to happen to them. They are in fear that from any time they are about to be beaten or they may be contact. Okay? So that is what we call assault. You have not beaten anyone, but you have put that person in a state of fear. Threat to apply force. That is what we call assault. When somebody apprehends, let me give an example. If you point at me and maybe you shout at me, you point and shout at me, you have not beaten me, but I'm assaulted in tort. You have put me in fear. I'm thinking that the next thing you're going to do, you're going to come and attack me. Okay? That is assault in tort. Let's pause a bit there. When a question comes asking you about assault and we are discussing tort, colleagues, I have intentionally not discussed the history of assault. So first go and find out, when do we first see assault in the societies? I think assault appears in slave and feudalism. So you have to first bring that history and then you answer. Let's now go to the elements. What must you prove for you to succeed in the tort of assault? Colleagues, there are two elements that you must prove for you to be able to succeed in the tort of assault. Number one, that there was a threat to apply force. Number two, that the act will put a reasonable person in fear of battery. There should be an act that puts a reasonable person in fear of battery. Okay? Two things. There is threat to apply force, and then there is an act that puts a reasonable person in fear of immediate battery. Those are the two elements you must prove. You must prove that the act of the defendant put a reasonable person in fear of battery, or that there was a threat to apply force. Let's begin with a threat to apply force. There is a saying here, a reading here, briefly, saying that as a general rule, pointing out yes, I wanted to get a model. Now, I'll give an example. If you point a gun which is not loaded to someone who doesn't know that the gun is not loaded, what do you think that person expects? That person is expecting, either is put in fear that you're going to shoot and they might lose their life. Okay? That is what we call assault. That there is a threat to apply force. Okay? Now, this one has been categorized in different forms. Look at a situation. Let's take under a threat to apply force. We have an order coupled with a threat. If you give someone an order, but that order is coupled by a threat, you have committed assault. Let's take an example. The case of Reed versus Coke. Write this case. Reed, the word Reed versus Coke, C-O-K-E-A-R. The defendant had, Mr. Coke had a disagreement with a business partner. So on having a disagreement with a business partner, he called the other team and they surrounded him and they told Mr. Reed that if you don't move out of this room, we are going to break your neck. Surrounded him and told him, if you don't leave this room, we shall break your neck. That is threat to apply force. You have committed assault. The beauty is, You have not even touched the person. You have only surrounded him. And you are saying, if you don't move out of this room, we are going to break your neck. So you're putting him in that state of fear that you are about to apply force to him. Threat to apply force. So if you give someone an order coupled with a threat, you have committed assault. Then another form, when you are discussing assault, we have what we call words alone. Now, listen. Words alone cannot amount to an assault. But when words are coupled or taken by with gestures or speech, okay, it now can amount to assault. That we are saying, the general rule, words alone cannot amount to assault. But what comes after, it might be speech, it might be silence, it must be gesture on the words, can amount to assault. Let's take an example of R versus Ireland and bust. R versus Ireland. Now, in this case, this man called people on phone, and when he calls, he keeps quiet, but is breathing heavily. He breathes heavily. So in court held that he had put those people, he had assaulted them in a state of fear that that something is about to happen to them. You call someone and you keep quiet. You don't say a word, but you're breathing heavily. R versus Ireland. So that one also qualifies. Then they're saying words can negate assault. That words can negate assault sometimes. That when you speak, your words can show that you did not intend to assault someone and there is no assault. Look at that case. It should be the case of Tuberville versus Savage, where the court had come in the area to handle issues. And one of the person, the defendant told the plaintiff that while holding his knife, that if it was not for the court to be in this area, I would show you what I could do for you. I would show you something. You see, saying, if it was not for court to be here, I would do this. Meaning that the words he had said have negated assault. That he did not intend to assault. Let me look for that case. Yes, words may negate assault. Yes, the case is Tuberville versus Savage. It's true. It's a true case. The defendant put his hands on his sword and amounted to a menace of threat, and therefore, and said, if it were not the court session time, I will not take such language from you. Okay? And it was told that there was no assault. Yes, he was holding the sword, an indication that he wanted to remove it and attack. But the words he used showed that he did not intend to assault. He said that if it was not for the court session, I would not bear your language. Okay? Meaning that he did intend to assault and there was no assault held there. Let's pause a bit. When a problem question comes about assault, they may give you words which have been used. So take note. An order coupled with a threat amounts to assault. Words alone cannot amount to assault, but where the words are coupled with gestures, with the silence, with the speech, then they will amount to assault. But again, words alone cannot negate, can stop assault, can negate assault. Take note of those two areas. So let's now go to what we call the act would put a person in reasonable fear of battery. The other element is, the second element, that the act you have done should put someone in fear of battery. That someone, they are about to be beaten, even when they are not beaten. For as long as you put them in fear that they are about to be beaten, then you have what you have just committed is what we call assault. Look at the case of Hearst versus Picture Theatres. Look at the case of Hearst. Hearst is H-U-R-S-T versus Picture Theatres Limited. This plaintiff had paid entrance admission to the theater. Okay? The defendant, believing that the plaintiff had entered without payment, asked him to leave. Okay? He was not afraid and refused to leave and would first be ejected. He sued for damages. The court held that the defendant were liable for assault and false imprisonment. Let me explain the case of Hearst very well. In the case of Hearst, he paid to enter the theater. You go to La Bonita, you pay to enter La Bonita. Now, the person, the owner of the show or the theater, thinks that you have not paid. So he comes to you. He begins to harass you. Move out. Okay? You didn't pay. Here to enter, you must pay. So, those words and shouting and refusing him to move out. Pay our money. You can't enter my nurse. Court held two things. There was false imprisonment, which we shall look at in the next video. And then court also believed that there was charge for battery. That this person was in fear of battery. Battery was about to happen because this guy was rude, the defendant. That you did pay. Okay? But this guy had paid. Maybe he paid, the defendant was not there. But he had paid his body. So that pressure, the threat put on him, put him in a state of fear of battery about to happen. And therefore, he sued for damages, which damages he was able to get. Note, there are many books out there with very many elements. But I have talked of only two: the threat to apply force and an act putting a reasonable person in fear of battery. Those are the only ones I have discussed. The only thing we can do now is reconcile with your lecturers. But those are the two widely accepted elements of assault. But various books, they break these into many. But those ones are the two that I have discussed in this video. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time, thank you. Cheers.